Hey guys, hello, hello, hello. Let me put this over by the comments here so I can see what's going on in the chat room. All right, I've been taking some hits from more than one person, and so I thought that, and a lot of these people I respect. I have a lot of respect for these people, so I'm not gonna like name names or anything. But because we testified in favor of House Bill 17. Is it scratchy again? Oh, hang on. My cell phone's over here again. Golly. All right, hopefully it fixes it. I don't want it to be scratchy again. So House Bill 1757, and let me go back to, let me look at something real quick. Just drop my pen. Ah. Okay, is there still a lot of static? I don't know what's going on here. Hopefully that fixes it. Gosh, I did that last time too, and I don't know. Okay, good. I guess I need to probably clean out these lines. Okay, good. All right, so what is House Bill 1757? Here's what the bill author, who is Matt Krause, who's a very good guy, here's what he has to say about the bill. It's related to recordings of peace officer performance of official duties and interactions with the public and creates a criminal offense. That's statutory language that they have to put in there. Now, what it does is it updates several sections of the code, and I when this bill was first introduced, I got a lot of questions about 1757, and people are like, "Hey, CJ, look at this and tell me what you think about it." And so I read the bill and I said, "Hey, I like it. This is a good thing. This is actually a really good bill." So I don't know what I still don't know to this day what people's opposition is to it. But I'm going to explain why I and Open Carry Texas support this bill, and I also want to address whether or not this has anything to do with Open Carry Texas, because what I'm told is this isn't even something that Open Carry Texas should be worried about. So I'm going to address that part first. Well, no, let's address what the bill means first, and then I'll get into why is Open Carry Texas involved. Sorry, I'm writing some notes here. All right, so here's what the bill does. This is a bill, so it adds section or article 2.13851 to the Code of Criminal Procedure, okay, chapter 2. And what it says is that during the performance of a peace officer's official duties, a peace officer makes a video or audio recording of the officer's interaction with a person, the peace officer must immediately disclose to the person that the officer is recording the interaction and the method by which the officer is making the recording. All right. So, in other words, if a police officer is recording you, and I'll get to the exception here in a minute, but if a police officer is recording you, this bill requires the police to tell you, I am recording this, either audio or visual. Okay. That's what that paragraph says. It requires them to tell you that they're recording you. I don't see why anybody would have an opposition to this. A peace officer is not required to make the disclosure under subsection A, which I just read, if the peace officer's interaction with the person occurs as part of an ongoing criminal investigation. So in other words, if you're under arrest for shoplifting or whatever, and they're questioning you, or you're on the side, if you're getting a traffic ticket or whatever, they're not required at that moment to say that they're recording you. They're only required under this bill, they are only required to tell you that they're recording if they're recording you for a non-criminal investigation. So I don't even see what's wrong with that section. Generally, every department has a policy anyway that requires them to record also criminal investigations. I mean, that helps them in the performance of their criminal investigation. So I don't see a problem with that paragraph. Someone correct me if they do. A peace officer is not required to make the disclosure under subsection A, which was the first section I read, immediately if making the disclosure immediately would be unsafe, unrealistic, or unpracticable. any justification for failing to make the disclosure immediately because it would be unsafe, unrealistic, or impractical is based on whether a reasonable officer under the same or similar circumstances would have made the same decision. That's just common sense. I don't see why anyone would oppose that section either. And just so you know, as of right now, there's no requirement for them to tell you that they're recording. Usually you can tell because they've got the red light on. So that's A, B, and C there. I don't see what anybody's got a problem with here. The bill also changes section 3709 of the Penal Code that makes section D3 now this is probably the part that I think some people probably have an issue with, but I'm going to explain why you shouldn't have an issue with this. Exactly, Turbo. It's a fishing expedition. So it adds a felony in the 3rd degree, and this is probably something that should be well, no, this is good too. So I don't understand why people have a problem with this, but it makes it a 3rd degree felony under section 3709 of the Penal Code for a peace officer, and now I'm quoting, for a peace officer or other employee of a law enforcement agency who alters, destroys, or conceals another person's audio, visual, or photographic recording of a peace officer's performance of official duties without obtaining that other person's written consent. Now, I don't understand why anybody would oppose that. If a police officer comes up to you while you're recording the police and he sticks his hand on your camera, okay, this right here, that's altering or concealing my audio or video. That's what this section says. That would be for a police officer to come up to me and do this. That makes it a 3rd degree felony. I don't understand why anybody would oppose that. All right, moving on. It updates section 3815, which, as anybody knows, is the interference with the duties of a peace officer. So this is section 3. Again, I don't understand why anybody would disagree with section 1 or 2. What I think is where I think the difference comes in between me and self-described First Amendment activists is section 3, because section 3 adds another defense to prosecution. And it says it is a defense to prosecution that the conduct engaged in by the defendant. Now, keep in mind that the conduct in this section, because it's section 3815 of the Penal Code, is disorderly conduct. So we're talking about disorderly conduct here. And this is a new section that's added to the disorderly conduct statute. That the conduct engaged in by the defendant consisted only of filming, recording, photographing, documenting, or observing a peace officer if before or while engaging in the conduct, the defendant obeyed any reasonable and lawful order by a peace officer to change the defendant's proximity or position. This is where I think there's a big rub. Now, here's why I support this, and here's why Open Carry Texas supports this. First of all, because it adds a defense. Right now, there is no defense to prosecution. There's no exception to prosecution for filming. And if you're arrested for filming, right, whether you move or not, if you're arrested because you're filming and they call it interference, right, there's no defense to prosecution. This adds a defense to prosecution for people who are filming the police. It says it right there. It is a defense to prosecution that doesn't currently exist if the conduct, the disorderly conduct that the officer is trying to charge you with, engaged in by the defendant, quote, consisted only of filming, recording, photographing, documenting, or observing a peace officer if before or while engaging in the conduct, the defendant obeyed any reasonable and lawful order by a peace officer to change the defendant's proximity or position. Here's the thing. The Supreme Court has already, and the courts have already identified generally what is a reasonable and lawful order to make someone move. And that's about 10 feet, 10 to 20 feet. Okay. This is already case law. Obviously, if you're up on a police officer's face, you know, and they're trying to do their job, they can ask you to move back. Now, the court has said that they can ask you to move back about 10 to 15 feet. Okay. The words in here, reasonable and lawful have legal meaning. All right. If they're telling, for example, if you look at, there's an Almost Park video of Jack Miller, who recently went back to Almost Park. He was carrying an airsoft rifle, and he was crossing the road, and Chief Salty Vagina, or not Salty Vagina, Valencia Retard, had come out, and I guess he was escorting other employees from the police station, and Jack was recording, and he had his rifle, his airsoft rifle on his back, and Chief Valencia Retard told Jack to get back, to go across the road. He had no right to do that. Jack had a perfect legal right to be there walking down the sidewalk. When Jack refused, and Jack was asking him, Jack Miller, Texas Sheepdog, was asking him why, if he had his taser taken away, and because I guess he wasn't wearing one that day. So they end up tackling Jack and injuring him. Well, then what the officers did was they forced the other people who were filming this way back. Okay. And any court of law, if they were to have challenged how far back Almost Park was trying to make these guys go when filming, it could not have been legally construed as reasonable and lawful. Okay. Now, maybe moving across the street would have been reasonable and lawful, because all they're doing, it's not like they've got a big scene that they're trying to secure. When they're doing a traffic stop, there's not a big scene that they're trying to secure. Depending on the purpose of the traffic stop. Now, obviously, if they're doing a high risk traffic stop on somebody who's, for example, just shot some people and is fleeing police officers armed, and there's likely to be a shootout, then that reasonable area might expand. But when we're talking about, and I'm talking legal terms, saying reasonable and lawful, believe it or not, it doesn't just mean whatever the cop says. These are legal terms that are defined by the court. Okay. So and that might be what people have a problem with, is oh, well, geez, you put that word reasonable and lawful in there. Well, that just means that the police can just tell you, no, they can't. It's got to be reasonable and lawful. All right. And that's what I think. But let's say they move you, and they don't like, and they want to move you again because you can still hear or whatever, and you refuse. This is a defense. Okay, this is a defense to prosecution right here, and all the attorney has to do is file a motion to dismiss, because they're not meeting the elements of this, because you did move to a reasonable and lawful, a reasonable and lawful place. Okay. So there's that. And look, without this bill, let's pretend we don't have this bill. So we don't even have to argue over this bill right now, but let's pretend this bill doesn't exist today, and a police officer tells you to move, right? And a police officer tells you to move a reasonable distance, which you do, and whatever, he tells you to, maybe he tells you to go to an unreasonable distance, and you end up getting arrested. Guess what? Without this bill, you're going to jail. You're going to jail for disorderly conduct, because there's no defense. This bill gives you a defense, and it gives you very legal terms that a prosecutor. Now, I know it says it's a defense to prosecution, so the burden is going to be on the defendant. But it's very easy to prove reasonable and lawful. Okay, reasonable and lawful. All right, the next section says this goes down to obedience required to peace officers. This is section 542.501. Peace officers, school crossing guards, and escorts. So what it does is it adds, instead of the word police under that section of the code, it changes the word police to the word peace. So instead of police officer, it says peace officer. And it says subject to subsection B. Now, here's the addition of subsection B. Subsection A1, which says a peace officer. All right, let me read this whole thing. A person may not willfully fail to refuse to comply with a lawful order or direction of a peace officer. Okay, this is already in the code. And what's added, the only thing that's changed is current code says that you can't willfully fail or refuse to comply with the lawful order or direction of a police officer. This changes it to peace officer, which I guess they're trying to make themselves sound better. I don't know. There's really no difference. It's a difference without any substance whatsoever. So, a person may not willfully fail or refuse to comply with a lawful order or direction of a peace officer. Subsection A1, which I just read, making it illegal, making it a crime to refuse to comply to a peace officer, does not apply to an order or direction to cease filming, recording, photographing, documenting, or observing a peace officer while the officer is engaged in the performance of his official duties. Did you hear that, folks? Why would you oppose that? This literally says in black and white that if a police officer tells you to stop filming, recording, photographing, or documenting, or observing the peace officer while he's engaged in his performance, that's not a crime. It just said right there, that is not a crime now. This section doesn't apply to that. Guess what? Right now, without this bill, it could apply. A police officer could arrest you for disorderly conduct if he tells you to stop filming. Okay? Now, I don't know how far that's going to go in court because we have a constitutional right to film, but why would you oppose it? This in black and white says you do not have to obey the order of a cop to stop filming or recording. So, and it also says it does not prohibit a peace officer from giving the person a reasonable and lawful order or direction to change the person's proximity or position relative to a peace officer who is engaged in the performance of official duties. Again, reasonable, lawful, reasonable, and lawful. Now, again, I don't know. Here's what, let me tell you. Okay, first, let me calm down. And I'm a little frustrated because these are very intelligent people. These are intelligent people that I work with, that I have interacted with in the activist world, who are telling me that I'm wrong. I'm on the wrong side of this issue. That why are you guys supporting a bill and we're opposing it? I just read to you why. That's the whole bill. That's the whole bill. Okay? And it protects us. It protects us. It protects all activists who film the police. But to sit there and say and tell me, your support of this bill really makes it harder for me to, help you with gun rights in the future. Let me tell you something. If your support for constitutional liberty is so thin that the actions of another person will prevent you from doing activism on that topic because it means more to them than you, then you don't really believe in that position anyway. For example, obviously, some of these people that have contacted me are on the opposite side of this issue than I am. And they're First Amendment activists. And again, I don't understand why you would be against this. As an activist, you should be supporting this wholeheartedly. And that's why we did. But just because you oppose it, what am I supposed to say? Well, geez, since you oppose this bill, I can't support the First Amendment anymore. Sorry, I'm not going to do any more stuff. You see how stupid that sounds? How stupid that sounds? It sounds very stupid. Now, let me tell you why Open Carry Texas, because another one of my criticisms that I've been giving is this is a First Amendment issue. Why is Open Carry Texas involved? The reason Open Carry Texas is a civil rights organization with a focus on the Second Amendment. And encompassed in that, in order for us to be activists for the Second Amendment, we also have to have an understanding and a defense of the First Amendment and the Fourth Amendment, as well as the Fifth and Sixth Amendments and some of the others, 14th. All right. This bill, even though it's a First Amendment bill, obviously the people who are upset at Open Carry Texas for getting involved in this bill have obviously never seen all the things that Open Carry Texas testifies on. We testify on first degree stuff all the time because our very existence requires an adherence to and an understanding of the First Amendment. Okay? In order to exercise our Second Amendment, we get up there and exercise our First Amendment. And by the way, when we are doing a Second Amendment rally or a Second Amendment event, or we're just doing something and the police get involved, guess what we do? We have a YouTube channel because people film the police. We film the police. So this is just as much an Open Carry Texas issue as it is an issue for all the First Amendment auditors. That's why we're involved. Now, I would like to know in the comments or in another video, if you want to tag me in it, why you oppose this bill. The only reason I can see that you would oppose this bill is because it talks about having to obey a reasonable and lawful order by a peace officer to simply move. If it's not reasonable or lawful, you don't have to move. This doesn't say you have to obey an order by a peace officer to change your proximity or position. It says you have to obey a reasonable and lawful order. Okay? And you have to decide that. You have to decide whether something is reasonable and lawful and how far you're willing to take it before you say no. Okay, I'll move to this part. This is where I believe the zone of reasonable and lawful is. And I can tell you that the closest is about 10 feet. I haven't seen anything closer than 10 feet. And it's up to each individual activist to decide where they want to plant their feet in the ground, where they want to draw that line in the sand. All right? And if you're an intelligent activist, an auditor, then you will make the right choice on where that line is. It's really not that difficult. Now, it's difficult for some activists and it's difficult for some cops for several reasons. One, it's difficult for activists because activists believe we should be closer than we are, and cops believe you should be farther than you're allowed. And so there's going to be that butting of heads, and it's going to be a legal issue. But what this bill does, 1757, House Bill 1757, what this bill does is it protects filming. It protects the right to film police, and it makes it a crime, a felony. It makes it a felony for law enforcement officers to cover your camera. It makes it a felony for law enforcement officers to turn off your camera. It makes it a felony for law enforcement officers to take your camera like they did with Jim and like they did with Jack, or I'm sorry, with Buck G, and slam your camera on the ground. It makes it a felony to do that. Why would anyone oppose this? Actually, Skip, I know, and Skip says reasonable is subjective and gets you a ride to the jail until a judge says what's reasonable. And I know that's what a lot of people think, but case law is out there. The words reasonable and lawful mean something in law. Okay, I was ignorant about this too before I went to law school. I was completely ignorant about, like, I thought the word reasonable was completely subjective. Believe it or not, reasonable is a very objective standard in law. I didn't know that until I started studying the law. And I didn't know that until I started reading case law. It actually means something. There is a legal definition of reasonable in the cases, in what's called common law. It might seem subjective because here's the thing. On the street, it's going to be subjective. On the street, both the activist and the officer is going to assume what they think is reasonable. But reasonable is not what's in my mind at the time, and reasonable is not what's in the mind of that officer at the time. It's what a reasonable and prudent person would believe in society is reasonable. Okay, and lawful, obviously, lawful means law. But reasonable, believe it or not, is an objective standard under the law. And I can't wait to become an attorney and be able to fight this idea of what police think is reasonable, because I don't think that issue is itself fought enough by attorneys. I don't think attorneys challenge this idea of what's reasonable enough, and that's what's got to happen. So I just want to kind of let y'all know, where did I get that mic? Oh, what's up? My boy's in here. I got this from Wish, of course. Where else do I get my stuff? It's actually a really good mic. It's the Golden CJG mic. Anyway, all right. That's why Open Carry Texas and I support this bill. This is why I asked personally, Rick Briscoe, who's our legislative director, called me and asked me about 1757. And I asked Rick, because he didn't sign up to support this bill, but I wanted to support this bill, so I asked him to testify or at least register in favor on behalf of Open Carry Texas of this bill. Okay, this is a police accountability bill, and I don't know how anybody can. I don't know what the argument is against it. I can only assume to know what the argument is against it, and I think the biggest problem that people are going to have with this bill are the words reasonable and lawful order to change defendant's proximity or position. Okay. And I'm telling you, that's not really something you need to worry about because those are easily defined terms under the law. All right. And with that, I'm going to take a couple minutes to keep this under 30 minutes. See if there are. Andy, I don't know. Andy says, what's the issue with those that oppose the bill? I really don't know. For example, I mean, I'll read several. I'll read several of these emails that I got. I'm not going to tell you who they are because I love these guys and a couple gals. I love these people who have reached out to me. I just think they're wrong on criticizing me about it. And by the way, the people who are criticizing me about it, they didn't go to the Capitol to testify against the bill. We did. We went to the Capitol to testify for the bill. So if you're not there and you're not testifying against it, and you're not telling me in your emails why you're testifying or why you don't like it, then essentially shut up. You know, it's one thing to say, oh, I oppose this bill, but it's another thing to actually go when there's a hearing on that bill and oppose it or support it. Because that's what they care about. Okay, I'm going to read one, and I hate to use this one because I really love this guy. But this really sort of encapsulates all the other emails and messengers and text messages that I've gotten about 1757. It's disappointing that OCT would come out in favor of a bit. And I'm only reading this one because it's the last one I got. Okay, I don't want to pick on this person. That's also why I'm not identifying this person. It's disappointing that OCT would come out in favor of a bill that I came out against. And I didn't see this person testify for this bill or against this bill, by the way. The bill has nothing to do with OCT's mission. Yes, it does. I've already explained that. There's no reason for OCT to even take a side. Yes, there is. I've explained that. Especially if your side is counter to mine. There are a lot of people in this audience, I guarantee you, don't agree with everything that I do. But I wouldn't tell you to stop. I wouldn't tell you to stop doing something. And then this part. This makes it difficult for me to fight for gun rights in the future, and I addressed that early on. If my position on a bill makes it difficult for you as an individual to support the Constitution, do you really support the Constitution? Now, I know this person does, and I know he's speaking out of frustration. But still, that's an odd statement to make. My opposition to this bill makes it difficult for him to fight for gun rights in the future. There you go. All right. Yeah, I literally just read the bill. And what I'm going to do here, I'm going to do this for y'all. And I'm also going to put it in the description below once I'm done. I'm going to give you can read the bill for yourself. There's the actual text of HB 1757. What I read, the only parts that I read are the parts that this bill changes. So if it's underlined, that means it's part of the bill that's being added to current law. If it's crossed through, that means the bill is repealing part of a law. And actually, those are the only two sections. So I literally read everything that was changed in the bill. I didn't read the whole bill because a lot of it is just a recitation of what's already the law. I only read what changes in the bill. And you can read it for yourself. And I really would like to know in the comments. I really would like to know in the comments why anyone, or you know what? We can do this as well. We can do this as well. I'm going to put the link, if you have StreamYard and you're watching this right now and you oppose House Bill 1757 and you're an activist, well, even if you're not an activist, go log on to StreamYard. I'll give you a few minutes. Log on to StreamYard. Come on to my channel. I'll bring you side by side, and we can discuss it. I don't know that the people. I'm trying to see if anyone. I can't see all 70 people that I'm showing. I can't see who all 70 are, so I'm not sure if the people I've gotten emails from are watching this video. What they want is a bill that says a cop goes to jail if they take us for a ride. We know we can beat. That's reasonable. I completely agree. I completely agree, Skip. That's what we need. I think if a police officer arrests you, you know that whole it's called being guilty of pissing off the police. I think that should be a felony as well. And it is a 19. I mean, it is a 1982 case. So hey, Otto, how you doing? I don't think any of the people that emailed me. I mean, at least they haven't chatted, so I don't know if they're listening or not. But I posted the StreamYard link. If you've got StreamYard and you want to tell me why I'm wrong or how I'm wrong, look, if I'm wrong, I'm wrong. But I just read the bill. I just read it paragraph by paragraph. I don't know how you can change my mind, but I'm willing to listen. I've had my mind changed on bills before. So, yes, the war on drugs does affect gun rights. Absolutely. And I'm going to do here. Let me do this real quick. Yes, there you go, right there. And as a matter of fact, here, let me pull that case up. I want to read something to you. I'm going to pull. Oh, you don't need StreamYard? If you don't need StreamYard, if you can if you want to just use that link and come over here and tell me why I'm wrong, by all means, please. All right. I'm pulling up a case here that I want to read to you. Nope. I think I spelled it wrong. I think that I think it's. I don't think that's spelled right. Trezvant. Let me see if I can find it here. I don't know if it is or not. Here we go. 741. Sorry, I'm in LexisNexis. I'm trying to. Oh, I might have spelled it wrong. Never mind. I spelled it wrong. That's what happened when I typed it into my search engine here. It's Trezevant. So it's not Trezevant like you see on the screen. It's Treze. All right. So here's what this court says. Now, here's the thing. This is the 11th Circuit Court of Appeals. Hey, HBO Matt, what's up, man? I don't think this is what I was looking for, actually. No, this isn't the case I was looking for. I'm sorry. It wasn't the Trezevant case. There's another case here. Let me just do. I'm sorry. Look, I'm done with talking about 1757. If you want to stick around and hear a little bit of case law, I'm going to find this case that talks about filming the police and distances. And I want to say, oh, look at that. There's Turner v. Driver. I know what that one says. That's not what I'm looking for. Whoops, dang it, spelled that wrong. Yes, I know. I type too fast sometimes. All right. Doggone it. Okay, I'm just gonna have to do this research some other time because otherwise it's just gonna be the most boring. And there's some Fifth Circuit cases. Now, if I remember, there's also like wasn't what's his name, Bueller, the Safe Streets or Peaceful Streets project. I think that's the case that talked about filming. Oh wait, here, let's find it. Because it's a Texas specific case. Okay, actually, I just found the yeah, Bueller v. Deere. Bueller v. Deere. And I'm trying to find the holding here. Oh, this is a summary judgment thing. This isn't going to give me. Okay, no, that's not it. I'll have to do some research on it. Plaintiff bringing excessive force claim. All right, let me get through here. Plaintiff also states that DeVries placed his hand on the side of plaintiff's head and pushed it into the pavement, while Garibay leaned his knee into the back and pushed with his full body weight. What's that sound like? And by the way, Bueller's a white dude. Plaintiff also asserted that McCoy placed her knee on his lower calves, holding him down during his arrest. Plaintiff states he had abrasions and bruises on his face, head, arms as a result of the actions, and that he also suffered mental pain as a result of the incident. The video footage shows 3 officers tackling the plaintiff to the ground, with a 4th helping to hold him down. Now, he wasn't running, by the way. I remember this case. This was back in like this was last year. While these injuries appear relatively minor, the actions that caused them, taking the evidence in light most favorable to the non-moving party, were unreasonable considering plaintiff's actions leading to his arrest, which were restricted to filming, and asking officers why that was considered interference. A third-party affidavit supports plaintiff's account, and the video footage states that plaintiff tried to back away from defendants and that they kept moving towards him, ultimately assaulting him violently towards the ground. Here, plaintiff was at most committing a misdemeanor and showed no indications of violence or of attempting to flee. As such, the need for any amount of force in effectuating his arrest was incredibly low. A reasonable jury could conclude that it was unreasonable for 4 officers to physically restrain plaintiff and hold him to the ground, causing the natural injuries that resulted from such action, considering the context in which the plaintiff's arrest. So this is because the court even said, look, all he's doing is filming here. And see, had this bill 1757 been law when this case came up, these officers would be guilty of a felony. So again, I don't understand why anybody opposes that. All right, I'm done. That's I thought that was the case, but it's not. It says a reasonable jury could conclude. See, there's that word, reasonable jury. The reasonable is an objective term under the law. Under the law. Leads the court to conclude that a reasonable jury could conclude that plaintiff was not an immediate threat to Deere, DeVries, Garibay, or McCoy. These are the 4 officers. So the last factor asked the court to determine whether he was actively resisting or attempting to evade. The footage here certainly does not provide so much clarity that the jury could not believe the non-moving party's account. So it looks like this was this was a good case because the Texas Western District Court denied the motion for summary judgment by the officers. And I don't know where this case is. If there's any, I don't see any subsequent appellant history. But this case was March 27th of last year. So who knows? It was either settled or it's continuing to move on. But all right. That's all I've got. That's all I've got. Yes, Taylor v. Rojas is another recent case that helps with. Now, what I would caution y'all on Taylor v. Rojas, don't put a whole lot of weight behind Taylor v. Rojas, and I'll tell you why. The decision is a very narrow decision, and it's in that case the actions by the police officer were like way overboard, way overboard on any standard, subjective or objective. And so while Taylor v. Rojas is a great case to cite to when you're doing an argument, the problem that a lot of people are going to have with it is the case will probably be distinguished based on whatever the current case is. And I'll tell you, unless it's a really harsh case, then Taylor v. Rojas is really got. I think the decision in that is very narrowly defined. Let me get rid of this. Hey, 123, thank you, sir. I really appreciate that, man. Thank you. I think it's a really narrowly defined case, so just be mindful of that. If you read Taylor v. Rojas, the case, you'll see the actions that occurred there were quite atrocious. I think it shocks the conscience is the word that the courts would use. And so if you don't have a case that shocks the conscience, I would say that what they did to Jack Miller in Olmos Park, Taylor v. Rojas could probably be used. Now that it's there, we could probably use it in our case, but they've already lost qualified immunity in our case. So I don't need to worry about it for Olmos Park as well. But I think just about anyone, I don't think anyone in Olmos Park, pretty much everyone that's been arrested in Olmos Park can probably use Taylor v. Rojas, but just know that it's a very narrowly defined case. All right. I do use Reddit, and yes, I look at liberal gun owners Reddit, and it makes me laugh sometimes. I have the Reddit app on my phone, son. All right. Let me see if there's anything else real quick. Police hurt white people too, is what you're saying. That's exactly what I'm saying. But we don't get the we don't get to go loot white people's stores when it happens to us, though. When it happens to us, we go to the Capitol, and then we're called terrorists. Oh, someone did write Bueller v. Deer in there. I didn't see that, government watchdog. But yeah, it's Bueh. Buehl is Bueller. I wish I had seen that. I wouldn't have had to search for it. That's the case I was thinking of. All right. I'll be home in about 5 minutes. I'm going to read over the whole thing. I know something about it, but I got to read it all. Picture perfect. What's going on? Yes, I am. Hope you're doing all right. You looking for? No, I'm not looking for Roe v. Wade, Chris. I love my troll son. I trained him well. I brought him up well in life. Can we move to 1758 now? What is 1758? Let me see. What is this? Also a Krauss bill. Krauss is generally really good about his bills. Relating to the operation and use of unmanned aircraft. I probably am not going to like this bill, Stephen. I can tell already. If they're trying to regulate, regulate drones, I can already tell I probably won't like this. I don't know what it says, so I can't comment on 1758. Oh, actually, it's a pretty short bill, though. Let's see. In this section, a person commits an offense if the person operates an unmanned aircraft that is equipped with chemical dispensing device, an explosive weapon, an improvised explosive device, or a firearm. They make those? What? What? Dude, if I had a drone that I could hook a firearm onto, oh man, I gotta fight that bill. Why is Kraus? I don't like that Kraus is but you know what? You know what though? Hang on, let me see if there's an exception to this. Anyway, an offense is a class A misdemeanor. It's a defense to prosecution that the actor is the owner or occupant of real property over which the unmanned aircraft was operating. Sweet! I could get a drone. Chris, do you hear this? Under HB 1758. Hey, F off Productions. Under HB 1758, even if that went into law, I could have a drone armed with an explosive weapon, a chemical dispensing device, an improvised explosive device, or a firearm, as long as I'm the owner or occupant of the property over which the drone is being operated. Or if you're a member of the military, okay, so the military is allowed to use armed drones, but we're not. Or it was equipped, the firearm was equipped with non-lethal rounds. That's another exception. I don't see an exception for police, though. It just says military. I don't see an exception for the police. So even the police wouldn't be able to have armed drones. Oh, that's it, though, man. I would have opposed this bill, but it says I can have armed drones on my own property. Dude, I could take out some hogs with that. But no, I still want to oppose that bill. All right, Hawkwind is in the wind after he said I was misrepresented. After he said I was misrepresented, when he was the one who was actually misrepresenting language. I don't know what is going on here about what language. My issue. Okay, I'm a bit behind the live stream, but my issue is the police deciding what reasonable, lawful order looks like. They don't care what laws are now. This is going to give them more ammo. I don't think it will. I don't think it will because this is actually putting them on notice. This is making them. It's holding them accountable for felony actions. So here's the thing. This is what a police officer is going to have to decide. Okay, because the police officer in deciding what is reasonable and lawful. First of all, lawful is very easy to define. But when we're talking about reasonable, the courts have also defined what reasonable is, okay? And it's very easy to argue in court because it's an objective legal standard. It's not an objective standard in society because what's reasonable to one person might not be reasonable to others, or what's reasonable to a majority might not be reasonable to a minority and vice versa. But the officer is taking a risk now because right now, without this bill, without 1757, if an officer decides it's reasonable and lawful to back you up 30 feet, right? And if you don't, he arrests you and prevents you from filming. You know, it's one of those things where they give him the benefit of the doubt or whatever. But if this bill passes and he does the exact same thing and it turns out that it's not reasonable, right? Then he's just committed a felony. So the officer's going to have to, in his head, he's going to think, okay, I don't like that these guys are so close, but are they unreasonably close? Because if I'm wrong, I can become a third-degree felon. And that's what this bill would do. I wouldn't doubt that the police opposed this bill. I don't see where they don't have the votes up yet. I don't see the witness list up yet, which is weird. How did someone else get the witness list and I didn't? Someone else got a copy of the witness list, which is how they found out that we voted, that we supported it. But I don't see it up on the website. I don't see the witness list up yet. But anyway, I'd like to know if the police are opposed to this bill because literally, it places the police officer in a very difficult position where he is going to have to choose between, okay, I had better damn well be right that when I tell these activists to back up and they don't, or they only back up to a certain spot, but they refuse to back up where I told them, All right. Am I telling them that that's reasonable? Because if this goes to court and it's unreasonable, I've just committed a felony. That's what this bill does under Section 2. If it is a felony in the third degree if a peace officer or other employee of law enforcement agent who alters, destroys, or conceals another person's audio, visual, or photographic recording without obtaining the person's permission. So I think this actually makes them less likely to be unreasonable. So was there another? Yes. Oh, yes. There's a vote on 1927 on Thursday. That is Schaefer's constitutional carry bill on the 15th. So that's Thursday at 10 o'clock on the House floor for the first time in history. 1927, which is better than 1911, although I would have liked 1911 because I like that number. But 1927 is going to be voted on the House floor. We expect it to pass the House. By the way, there are 2 Democrat co-authors on this bill on 1927. And the great thing about 1927 versus 1911 constitutional carry bill is that, hey, Top Horse Solutions, that case, I don't know if you'll be able to access it. It's a Lexus case. I'll put the citation in the chat there for you, but unless you have a Lexus account, I don't know if you'll be able to access it. But there's the citation for it. But yeah, the great thing about Schaefer's bill versus White's bill, although I'll take either of them, is that Schaefer's bill doesn't tie the ability to carry without a license to the license itself. So under White's unlicensed carry bill, you could carry without a license as long as you could qualify for a Texas license to carry. So you have to meet all those conditions of the Texas license to carry if you want to carry without a license. Schaefer's bill, the one that's getting voted on Thursday, is if you can legally own and possess a weapon, you can carry it without a license, which is what we want. That's the better of the 2 bills. Because there's no reason if you can legally own and possess a gun, you should be able to carry that gun. It's keeping bear arms. So what I can also do, Top Horse, if you send me an email to cj@cjgrisham.com, I will send you the Bueller case in PDF format. cj@cjgrisham.com. I'll send you the Bueller case in PDF format if you can't find the text of it. Just let me know that's what you're looking for, so I remember, so I know. Okay. All right. It's literally. All right, guys. I mean, we're all on the same team, right? We're all on the same team. I have a non-resident Texas license, so I can conceal carry here in Nebraska. Sweet. Nebraska. I thought Nebraska was constitutional carry anyway, Skip. If I'm not mistaken. Or is it just unlicensed open carry? All right, guys. I'm gonna take off. Okay, I'm glad y'all fixed that. I know we're all on the same team here. I do want to again thank Juan23 Senior for the $15 donation. I will keep that in my account for when we need it for an event. And also thank you all for being here, everybody. I hope you learned something. And be safe and be free. And Chris, mow the lawn or something. Just kidding.